Join us every Wednesday for InFocus, a weekly talk show produced by the SKNIS Information Service, where we provide exclusives with key persons within the government and discuss pertinent, relevant, and interesting matters that affect us all. Tune in every Wednesday, live on ZIZ Radio and streamed live on Facebook at SKNIS Media and ZIZ Online. InFocus, your government, your business.
I'm Ian Richards. Welcome to InFocus, a weekly program where we zoom in on what's happening within and throughout the government, your government. The government recently passed a number of crucial pieces of reform legislation that aim to strengthen the nation's criminal justice laws to reflect the continued transformation into a thriving, sustainable democracy. There are now increased penalties for crimes against the person, as well as gun-related possession and use, as the government enhances citizen security. There is also new legislation that guards against the use and abuse of the Citizenship by Investment program from unscrupulous malefactors. Our discussion today on these topics and more will feature the Attorney General, the Honorable Garth Wilkin, and the Director of Public Prosecution, Adlai. Stay with us as we delve into your government, your business. Welcome back to InFocus. It's my pleasure to welcome the Honorable Attorney General, Garth Wilkin, and Mr. Adlai Smith, the Director of Public Prosecutions, back to InFocus. Gentlemen, it's good to have you back.
Good to be back. Good afternoon.
Yes, good afternoon, yeah. Good afternoon.
Right. So last year, when the two of you were here initially, you spoke a lot about criminal justice reform and some of the things that were going to be done to enhance the system here in St. Kitts and Nevis. Can we get an update on measures to reform that system? What was done to date?
Well, I guess I'll start, and DPP feel free to jump in.
Yeah, jump in.
So we were here in November, and what we said was we would introduce new laws to speed up the criminal justice system, strengthen it, because we felt that it is an important aspect of our democratic society. So what we've done since then is we've formulated plans, we've joined programs, internationally sponsored, partnered with our international partners to do training, and we have gone to Parliament and done some work. So the first phase, I would say, of the reform has been the updates to the firearm-related offenses, increasing the penalties. That was after some stakeholder discussions, frank and open discussions with all of the various stakeholders, customs, the police, national security, the DPP's office, etc. And what we thought was a appropriate penalty for the scourge, to deal with the scourge of gun crime that has been affecting us for the last probably 15 or so years in St. Kitts and Nevis. So we amended the Firearms Act. We then amended the Offences Against the Person Act. One of the primary criminal justice specific measures that we brought to Parliament was the Justice Interference Prevention Act. After discussions with the DPP and persons in the court system, we felt that there was a burgeoning problem in relation to witness intimidation and juror intimidation. So we felt it was necessary for us to create a specific law that criminalized interference, harassment of witnesses, and other interference of witnesses and persons involved in the judicial process, so that there can be a fair process, not influenced by criminal elements. So that was a direct law. Another one that we are going to table on Friday, because there's Parliament scheduled for this Friday, which I believe is the 5th.
Yes, and for those who are watching, yes, you just mentioned it's on the 5th of July.
Yes, so
we rebroadcast, so sometimes, it would be a bit like if it plays on Sunday, so they might misunderstand the Friday.
Oh, okay. Oh, sorry,
Right,
sorry. Yes, on July 5th.
Yes.
Yeah, apologies, Ian. We're going to table the voluntary bill of indictment bill, which I will let the DPP speak a bit about afterwards. That's also a direct criminal justice system bill. We have a few more in the pipeline, which we'll discuss as we go along in the program. But one of the other important things that we've done is that the PACE Justice Project, which was launched in October 2023, their project team came to St. Kitts and Nevis. They met with the stakeholders, including the DPP, myself, and the other elements of the criminal justice system. And we agreed on the scope of their support, technological implementation, training, and other support. So that first step, that first hurdle we have crossed now, and we're going to go into implementation phase. And to do that, what we have done is we've engaged a specific consultant to guide us through the process of the PACE Justice project, as well as the El Pacto 2.0 project. So let me explain what both are. PACE is an EU-sponsored, UNDP administered program that helps to build institutional capacity for the police force, prosecutors, lawyers, courts, prisons in certain Caribbean territories, which we are part of. El Pacto 2 now is also European sponsored, and it is a program that is helping the countries that are part of the program, Latin America and Caribbean, to deal with transnational crime. So it's training, funding, etc. So those two kind of work in parallel. They're not the same, but they both help us to benefit our criminal justice infrastructure. So the specialist consultant is going to work along with those projects and guide us through. So we have a dedicated person now that's going to get us over the various hurdles so that we can ultimately benefit. I'll be frank and honest with you. In a small jurisdiction like ours, where we have limited human resources, it's difficult to take full advantage of these projects unless there's somebody whose time is dedicated to these projects. So part of the project is also legislative drafting. So the consultant will engage a legislative drafter to then bring some of the other criminal justice laws that we want to implement. So we felt it was necessary to have that capacity, to build that capacity to take advantage of these EU-sponsored projects. Also, we had a civil asset recovery training workshop, which took place in, I believe it was April this year. The DPP was part of that, as well as the persons from the customs, from the white collar crime unit, DPP, who else was
Inland Revenue, I think.
Inland Revenue, and that deals with asset recovery so that we can build our toolkit in seizing assets that were gained through criminal operations. And what that does is that tells the bad guys, stay away from St. Kitts. Don't include us in your international crime network, your highway. You know, we don't want to be a stop on that highway. So what we do, we build capacity. This one was a partnership with the Bureau of International Narcotics and Law Enforcement Affairs and the National Center for State Courts, which are U.S. entities. And it was a 2-day session, right, DPP? And I
2
think,
days, right,
yeah,
right.
And you know, it's to build capacity from all the different elements. As I said, customs, inland revenue, DPP's office, etc., AG's office, so everybody can have an idea as to what is needed for civil asset recovery. Because if the bad guys are fearful that they're going to lose what they gain, their houses, their cars, their jewelry, and so forth, then it's a deterrent to them to bring St. Kitts into the fold. So those are some of the things that we have actively done since we were last here in November. How many months is that? November, December, and 6? Yeah, so 8 months ago.
8 months, yeah.
Time flies.
Yeah.
Yeah, but we've been working. It's not an immediate fix. We also had a Justice Committee meeting. I believe it was either the last week in May or the first week in June, where we kind of agreed the roadmap of what the priority areas are for the next set of criminal justice reform. So we hopefully at the next sitting of Parliament we'll have the judge-only legislation to be tabled so that we can have that in place for September. And what that does, when you put the three laws that we intend to have in place first, which is the justice interference, the voluntary bill of indictment, and the judge only. It helps us to speed through some of the high-level criminal matters through the system, get them out to the system, especially when it involves vulnerable witnesses or witnesses that have been subjected to threats. You don't want to have witness interference. So you have this kind of triarchy of laws to help push it through. And then the judge-only provisions, which we're going to have stakeholder consultations over the summer before we hopefully have it debated in September, is to, in certain provisions, certain types of cases, instead of having a jury, it'll be the judge only. A lot of jurisdictions are moving towards this. Antigua has moved towards this. Trinidad has moved towards this. Bermuda,
Turks and
Caicos, and it's been successful. Right. So what we're going to do is we're going to have that stakeholder consultation, because that one is a little more controversial than the other two, and see what is said, and then move forward with the consensus. But we believe it's necessary because when you have 12 jurors, persons who leave a case and go home and could potentially be subjected to some sort of intimidation. I mean, fortunately, knock on wood, we haven't really had direct violence in relation to our jurors, but we want to, the criminals are becoming more sophisticated, they're more electronic means of communication, and we want to ensure that they are protected so that justice is done from a pure level. So all of those things we've done so far. We have the plan. The consultant is going to define our roadmap and get us. It's a 18-month project. So hopefully, when we come back here in 18 months, at the end of 2025, we could say, Ian, we believe that all of the infrastructure is in place to have a fully functioning, efficient criminal justice system where people are not waiting for years for justice. Justice is done fairly. All of the training is there, all the technology is there. We're taking advantage of AI, we're taking advantage of computer systems. Everybody's on board, from the prisons, the police, the prosecutors, the court workers, everybody. And we have a modern criminal justice system. That is my personal goal. As a member of the implementation committee for the Needham Point Criminal Justice Reform Project, I want to lead by example. It's easier. Our size is our strength in this regard. Being a small jurisdiction, it's kind of easier to implement some of these processes. And that is the goal. The goal is to have an efficient, fair justice system that is fair to the accused and fair to the victims, so that we can have a fair society that helps to build trust in the society, and hopefully that will encourage people to stay away from crime and violence.
Mr. Smith, the AG said quite a mouthful.
Yeah, he said quite a mouthful. He took up some of what I was going to say, but still, at the same time, it's a joint effort, because we're all joint stakeholders where the criminal justice system is concerned. Just to add, with respect to the justice interference legislation, no one has been charged under that legislation as yet. There have been multiple instances of witness interference. I don't want to say it's quite as if witness interference is on steroids in St. Kitts and Nevis, because really and truly that phenomenon is predominant in cases where you have a gang element or a murder case. And speaking from practical experience, I see that there's a lot of room for improvement.
Right, but that is one of the topics that I had actually intend to pull out and talk about a bit later. A specific section related to that, because as you mentioned, there's a whole number of issues that can be explored and discussed there.
Let me not steal your thunder.
So,
right? Just to add to what the AG has been speaking about, speak about the Voluntary Bill of Indictment Act. The whole idea is to have, well, first of all, an indictment is basically a charge at the High Court, for those who don't know what an indictment is. Criminal process normally starts in the magistrate's court. But the whole idea behind voluntary bill is to leave out the magistrate's court and start it direct in the High Court. And the whole idea behind that, remember the last time I was here, I was complaining about, I don't like to see the fact that you have people on remand for 3 and 4 and 5 years. We're talking about situations where persons' potential breach of their constitutional rights is coming into play. And we want to avoid that. We do have a provision which allows for voluntary bill of indictment under the Magistrates Code of Procedure Act, Section 75, whereby once I'm satisfied that certain conditions have been made out, I can issue what is called a notice of transfer, and I can sidestep the committal procedure in the Magistrates Court. And I have been using that, because the whole idea is to try and bring matters up, and I've been using that particularly in relation to recent murders, right? Because the goal, I mean, it's an ambitious goal, but the goal is, I mean, once you decide to go and shoot somebody with a gun or something like that, and you've been charged for the offense, once the documentation has been prepared, insofar as witness statements are concerned, I will file a notice of intent to transfer, and we'll move that matter swiftly within the Magistrates Court. Sorry, through the Magistrates Court, because that's to start there, just formally, just to tell them the notice for transfer has been filed, it's been served, etc., and we start the matter in the High Court. We put it up, set it down for trial as soon as possible. The whole idea is to try and see if we can have these matters tried within a calendar year. And the reason for that, why I want that trial within a calendar year, I want to minimize that window of opportunity for interference with witnesses, right? If I can bring the matters up closer, I reduce that window, which is very handily being used by, miscreants for the time being. So there is that. Also, we're trying to see what we can do in terms of witness anonymity. We do have witness anonymity in our evidence legislation right now. Of course, there's not every circumstance where witness anonymity is practicable. When I say witness anonymity, what is that? Well, persons who are afraid to give evidence because they have been threatened.
But I think you're drifting back into the tampering witness part of it that we wanted to discuss a bit later.
Oh dear. So, sorry, well, I'm just telling you what is on board.
Instead, right. So let me ask then, in terms of, because one of the important things that were discussed the last, was discussed the last time, I should say, was the use of technology. And it does, I imagine, touch a bit into the witness anonymity part of it that you were mentioning as well too. But has there been any progress in terms of including technology in the courtroom, including technology, whether it is to give evidence or to enhance the collection of any exhibits or whatever that would help to speed up criminal justice in St. Kitts and Nevis?
Well, if you're talking about giving evidence remotely, that's a position that's been a part of the St. Kitts justice system for a while. I mean, it was here even before I came here. I'm talking about giving evidence via Zoom, electronic platform, so you're at some other location unknown and the jury is able to see your face on a TV screen, judge is able to ask the witness questions, lawyers are able to ask the witness questions, jury able to ask the witness questions.
And that was a bit more in play during the COVID experience, of course. We saw that a lot. But in other aspects of technology, any other aspects, and you mentioned AI in particular, is there any other aspects of technology inclusion that you have seen happening here or that is set to come?
Well, there is hope. Let me say there is hope. There's hope insofar as transcription is concerned. Yes. We here in St. Kitts have been fortunate to be part of a pilot project with respect to transcription, which is done live via AI and simultaneously. Right, and it's been very interesting. It's had a few mistakes. They've done it pilot project for the civil aspect of it, but I think there are plans to put it into the criminal justice arena, and of course there will be multiple benefits where this is concerned once it works properly, and so on and so forth, because you'll be able to get transcripts quickly. You might be able to get transcripts maybe even at the end of the day, after trial and so on, to go home and review, plan your strategy for the next day or something. And the preparation of transcripts now means that you have appeals being prepared even faster. Of course, that's only part of the problem, because you need persons to do the appeals, you have lawyers to not just prosecute but defend the appeals and so on and so forth. But at least it's a step in the positive direction. We've seen it in action. The only thing is, though, it's not able to pick up that hardcore St. Kitts accent. And even like bye and so on and so forth.
You're learning some St. Kitts
Yeah. I mean, like, when I'm here, petition. Right, but the point is, it's not picking up some of the dialect. But you see, even so, the person who is monitoring the device can actually make live changes and so on and so forth. So
and that doesn't
isn't
impact
too much of a
the computer or the AI, I should say, continuing to record what's happening. That doesn't impact it at all.
No.
This thing is really fancy. A program called For the Record. And I think there are benefits to be right from that in the future once we use that.
I had a friend who was questioning if night court is continuing to deal with traffic matters.
It's a very good question.
Oh, that
I'm not sure.
Yeah.
I haven't inquired recently. But at one point it was implemented. I'm not sure if it's been implemented up at the new court, but I'll find out and let you know.
Right.
Yes.
Okay. And then what would you say needs to be done in the short term to achieve the specific objectives? Of course, we spoke a bit about some of the new bills that has come in. Anything else that needs to be done in the short term?
Well, in the short term, you see, and here's the thing. I have to prime up myself for what I'm about to say. Parliament can pass all the laws it wants, right? But unless the citizenry of the country come forward and take part in the justice process, it will be all for naught, right? And let me start by making reference to a quote I saw just last week. If I choose to remain silent, I'm guilty of being complicit. It's a quote by Albert Einstein. And that applies so much more so to the justice system than anything else. If you see something wrong being done out there and you remain silent, you're just as guilty as the perpetrators who are doing these acts. And the problem is persons, for whatever reason, and I'm not saying that they're not good reasons in some instances, but they are not coming forward with the information that they know. Or sometimes they come forward with the information, but they don't want to be on record. They don't want to be witnesses in the matter. No, you can't prosecute a case based on hearsay. At least not until we change the hearsay provisions to modify in certain instances. But the AG and I are still talking about that because they need to make reforms where the hearsay issue is concerned. But coming back to this, I made reference in a speech I did in court recently about your coat of arms. Your coat of arms has one of the best mottos in the entire world: country above self. It means that persons, citizenry, put aside their self-interest and they put the national interest above all for the greater good of all. And you see, what I'm noticing is that persons are saying, well, boy, not me, I have this to worry about and that to worry about. But when it comes to them being offended, they want other people to give evidence in that case, and that is unfair. That is unfair. I'll give you one practical example. Not directly, but to illustrate the point I'm making. When you don't come forward and say what you know. I had a situation a couple months ago, probably sometime last year. Man caught on camera. His face was masked and so on, but he had a good portion of his face. We saw two individuals who we knew could identify this individual. One lied and said he didn't know, and the other one says he's not taking part. She don't want to get involved, right? Well, had to withdraw the case because you can't prosecute a case unless there's evidence, right? And guess what? I'm seeing now that person, same name, coming up for rape. So you see, when you fail to act, to see justice being done, you're putting the rest of the citizenry at risk. And I have to speak out about that. I'm sorry, Country above self must be something more than you stick on your shirt, or you stick up on the wall, or you stick up over the judge's head in court. It has to be something that means something for petitions. And I'm sorry, but that's something that I believe in.
And the visions.
Yeah, if I could jump in.
Go ahead.
Yes. DPP is passionate about it because he's in the trenches. When you see people getting off, people who've committed serious crimes, rapes, murders, serious violence on other people, and you know that there's someone who could give the evidence to get that person off of the street so they can't do it to someone else, you get passionate. And part of the problem is we live in a very small society. So there is a natural fear. Sometimes when you see a crime, it's somebody you know, somebody you grew up with. You know their parents, you know their auntie or something like that. So from the parliamentary and government perspective, what we try to do is create policies and laws that help people feel more comfortable to take that step, to be part of the criminal justice system. The most important part, which is that of a witness. So when you see the justice interference bill, when you say, listen, you are protected. If a person intimidates you, harasses you, sends you a text, let the authorities know. The DPP can then prosecute that person. That person can be behind bars and cannot interfere with you. What we're also doing as well, which is actually probably even more important than the justice interference process, is we are developing a witness protection infrastructure, a network in the region and outside the region. So if you are that person that witnesses a double murder from the window of your house, and you fear that if you go into the witness box, something will happen to you, we will have international partners that will have treaties with us so that we can get you somewhere else, so that you can feel safe to give that evidence, whether virtually or otherwise, and then you will not have to live with that fear. And then those two double murderers will be prevented from going onwards and onwards to creating more havoc in our society. So it's not just one law that we're seeking to help this. It's not just, also the speed. When you think about it, the speed of if you have a serious crime and there's an arrest and a charge by the police, and then there's a prosecution within 2 months in specific matters where you know that it might be gang related and there are potential threats to the witnesses, you can speed up that matter. Ask the DPP can now, after the voluntary bill of indictment is passed, can ask the High Court judge, listen, this is high priority because of X, Y, and Z. And then that matter can now be tried quickly. The risk of interference is then reduced, and we can have justice being done swiftly.
I think this would be a good time, AJ, for us to have a discussion then, as you talk about interference on the Justice Interference Prevention Act, because it seems like it's been crossing over a lot into the conversation, which shows that it is something that is very vital.
Very much so.
Very vital that has to be addressed. But before we get into that discussion, we have to take our first break. We're up against the clock. Stay with us. We'll be right back with more In Focus. Welcome back to In Focus. We are here with a very lively discussion with the Attorney General, the Honorable Garth Wilkin, and the Director of Public Prosecution, Mr. Adlai Smith, and we're discussing criminal justice reform. And we left off, gentlemen, on the Justice Interference Prevention Act. Now, it was passed in the National Assembly, AG, in May 2024, and it was designed to protect against interference in legal proceedings,
yes,
as we've established earlier. Tell us a bit about what actions the Act classifies as interference.
Intimidating, harassing, harming, threatening, or bribing any of the persons involved in the court matters. So jurors, witnesses, judges, persons assisting in the investigation, etc., etc. So what it does, it also separates the different types of offenses and creates a different penalty for each of them. So for example, threatening someone is slightly different to intimidating.
What's the difference?
Intimidate, threatening is actually, you actually say, I am going to harm you. Intimidating is more of a, it's a more of a like
I guess you're like a stare.
a stare.
Let's say you're naturally ugly, and you look hard at somebody. Some people are intimidated by that, you know, and some people know. I mean, granted, it's a joke, but you understand what I'm saying. A look, especially when somebody knows that you're a snitch, or an informer, or something. Just look. All right.
So that statement, if looks can kill, you're saying now that it can be interpreted
Yes,
as
but
something.
You have to look at it in context.
Yes, of course, it has to be contextual. Yes.
Just a look.
Right.
Right? I mean, there's certain circumstances, if you think hard enough, you will understand where a certain look at a certain place can be intimidating to an individual.
And you have to have proof, and you know it's all contextual. It's not that anybody who is the family member of an accused who looks at a witness in an angry way will amount to a breach of the act. You know, it's not about that. It's really there because we have and I know the DPP is very passionate about this as well. We have a bribing issue when it comes, particularly in sexual matters.
Oh,
It is cultural. When I was a prosecutor many years ago, most of the matters I did were sexual matters, and almost all of them they were offers, financial offers to the virtual complainants, the victims. And I know this has continued. It is a societal ill, and what we're trying to do by this legislation is to prevent it by deterring persons from offering money for persons to walk away from serious sexual offenses, which is a practice that has happened for many, many years. Different stakeholders have participated in that type of matter. But also the threats. I'll give an example. And I gave it in Parliament when we were debating. A witness got a call from the accused from prison. A threat. We can't have that. Because what will happen now, just say rubber hits the road. Say somebody is accused. They now get their disclosure of their deposition. They see who the witnesses are, the key eyewitness. And they sneak in their phone into prison, which we're trying to deal with from a government perspective. And they call or send a text and say, if you go to that witness box, I'm going to XYZ. That person now can be charged under the JIP, which I call the Justice Interference Prevention Act, independent of their original charge or with the original charge. But independent of, and then believe you me, that person is not going to get bail because with that particular charge, it shows that you have a propensity to interfere. Because one of the reasons, the considerations of the court in granting bail is whether there will be intimidation of witnesses or interference with witnesses. But also, the DPP could potentially prosecute that particular crime under the JIP. Quick. Get a conviction if there's solid evidence. And that person could be in prison for potentially longer than was the original offense. Well, say it was a causing a GBH, sorry, grievous bodily harm. So not necessarily a stab, but like you hit them somebody with a plank, and it is more than just a basic assault and battery, and it's an indictable offense. And DPP, typical, if you hit somebody with a plank, they get maybe like a broken arm or something like that. Yeah. What is the sentence? A couple of years. You might get a 2-3 years. But if you know while you're on bail or while you're in prison or waiting on remand, you call and threaten the person that you hit, saying don't show up to court, you could be ending up spending 20 years.
Well, that's the maximum.
Max.
Right.
Up to.
Yeah. See.
So you have to start to think about, are you going to do that? And that's an extreme example.
Right.
But it's an example to show that it is independent now of the original offense. Now the original offense might be murder, right? And then, but you could then now while you're waiting for your murder case, which it might be more complex, maybe a complex murder that's going to take a year or two to reach a trial, the DPP could take your text, do the what do you call it, the trajectory to find out where the call came from or the text came from, link it back to your cell and thing and prosecute you in a simple JIP prosecution, and you could be in prison on a conviction awaiting your other trial.
Right.
AG, we don't want to tell them about all the investigative techniques. Right? We have to surprise, we have to use the element of surprise. Right? But coming back, that is the hypothetical element. The practical side of that is, and I mean, I've thought about it, and I'm thinking, well, here we may have to go back to the drawing board somewhat. The person who doesn't give evidence because of fear, right? If that person has been threatened and so on and so forth, how are we going to get that person to give evidence that they've been threatened by somebody else? And that's the challenge for me, right? I mean,
and witness protection then comes into play.
Oh, witness protection is a whole, because I am in the trenches where witness protection is concerned, right? And AG promised that I'll be able to speak to the cabinet about this whole issue of witness protection. I'm eager to, right? As we're talking about witness protection, there is a need to be more empathetic to the persons who are in witness protection, right? I've had to step in to talk to witnesses and console them and so on and so forth, and even speak to them about, you know, the way forward and so on and so forth. That should not be me. If you had a witness called me who has been in protection, and he said, DPP, you doing that too? And I said, but if I don't do it and that system fails, that's it, you know.
Yes.
Witness protection technically will be the only thing that will save the justice system for St. Kitts insofar as gang-related and murders are concerned.
St. Kitts and Nevis.
St. Kitts and Nevis. And sorry, witness protection, we must realize too, is something which is very expensive.
Yes.
And I mean, sometimes I wonder how much can the government really apportion towards witness protection, granted how important it is. So we have to make sure that when we're utilizing the resources are utilized in a rational manner, in a rational way. But I spoke about the importance of speaking to people. And the reason why I say so, when we ask a person to go into witness protection, we're asking them to give up life as they know it.
Yes.
No person in witness protection is perfect. They might do a little thing here and there and so on, but if they do a little thing that irritates somebody, and that's no reason to take them out of the program. Right? Witness protection is, I don't want to say it's like voluntary imprisonment, but it's, you're basically saying that, you know, I've given up how I do my ordinary way of life, how I deal with my children, my spouse, and so on and so forth. It's not an easy thing to go into witness protection, and I am conscious of that.
And you often consider what happens to you after as well too, after the case is over.
Yeah. Right, so there are different issues in relation to the program that I have to raise to the cabinet, having regard to dealing with witnesses who are in witness protection program. And I tell you, these are things that keep me up at night.
And one of the things that we've discussed in relation to that is introducing witness counselors. So persons who are, when a matter comes up, a person who is specifically assigned to the witnesses to keep them updated. This is what's going on in the progress of this matter. This is what is happening. When they have issues, they want somebody to talk to. So it doesn't have to be the DPP. So that's a human resource issue. When it comes to human resource, what does that mean? Budgetary assistance.
But it also has to be someone, AG, who you would consider to be trustworthy.
Yes, of course.
Because, you know, I mean,
yes,
that person would have access to where I am.
Yeah, exactly.
Access of how to get to me. And I appreciate crime may not be as organized as it is in some other countries, such as in the US, where, you know, they can travel from A to B. But we don't underestimate the criminal elements and their creativeness.
Yes. And that is what the fear that the DPP has. They are sophisticated in the ways they do things. So we also have to be equally sophisticated in the way we protect witnesses. So I mean, we've been fortunate, knock on wood, that we haven't had any major incidents that I am aware of. But what we want to do is prevent that. And what we're discussing when DP says he wants to come to cabinet, because he wants to show cabinet how passionate he is. I mean, I try to relay his passion, but you can't. The person in the trenches knows.
Yeah, that's going to be hard for you, AJ.
I have been in the trenches in prosecution for over 10 years. So, you know, it's important that we figure out a way to protect our people so that they feel safe to participate in the criminal justice system. We also toying with the idea of juror switching. So in using the OECS, so the AGs have had a preliminary discussion on that. What we're trying to do is collaborate on certain things. So we're going to create a treaty, which they've tasked me with drafting, which is going to kind of have our specialized investigators collaborate. So if there's an investigator that's specifically skilled on a particular type of sexual offense, that person will come in and our people who are specialized in a certain type of investigation will go there when they have those. So we're going to share that. But one of the things we're discussing is also sharing jurors. So for certain types of matters where there might be somebody that is well known, or you know, but they're not going to be well known in Dominica. So we're trying to figure out a way potentially where we could build a jury from another jurisdiction to come in and sit on the trial and then go back. But that involves expense. So we're in the embryonic stages of discussing that. We're also trying to have a regional hub for DNA, so that we can expedite our DNA results that are important to prosecution. So those are the three things that we are discussing as the AGs in the OECS to kind of figure out how we could collaborate to work together, because the issues we have here are similar issues they have elsewhere, right? So we can work together and kind of strengthen each other by working together. So that's one of the things that we're trying to do.
Yeah, I particularly like that idea in terms of jurors from another jurisdiction, because just take an example in terms of, we see it a lot in the United States. And we take, for example, Donald Trump, the former president, who argued, can he get a fair trial in New York? Of course, he's a very well-known, controversial personality, and there are persons who either love him or they hate him. And so that was the question that was asked. Now, in situations in St. Kitts and Nevis where persons are well known, we have, of course, quite a number of persons who would fit that bill, whether it is in politics or entertainment or for whatever reason in industry. Then the question would ask, can they get a fair trial in St. Kitts and Nevis? Considering the population is so small, there's only that limited pool. So this expands the pool now, where persons, as you mentioned, from other territories don't necessarily come under that influence of celebrity or stargazing or the power trip that persons may have.
Yes, so we're discussing that. I'll see where we all kind of had a in principle agreement to start the discussions. You know, the logistics of it are very difficult, the expense of it, and so forth. But that's all also to witness protection. You know, so.
Oh, but to deal with that same issue, if somebody is very popular, you could have it as a judge alone offense.
Exactly. So that's why the judge alone legislation is going to come in.
Right. You save a lot of money that way. I mean, judge alone has potential advantages, right? And Antigua has most of its offenses now tried as judge alone. Most of the offenses. I'm not necessarily saying that we will go that particular route, but certainly if you have situations where there's threats to witnesses and so on, I would advocate for judge alone in those instances. Gang-related matters, judge alone. Sexual offense cases involving children, maybe not, right, in certain circumstances, maybe. But the combination of judge alone trials and jury trials could have the potential to save judicial time. Like, for example, if you start a jury trial, or you start a jury trial, the jury trial, maybe it stopped short for some reason, right? If you have a floating list of short judge alone trial, because remember, you don't necessarily try a judge alone straight in one day. You can adjourn maybe to a week after to continue it, or 2 weeks after. So if you have some reason where a jury trial has to be adjourned, You can call at a moment's notice something on your floating list to fill in that time so the court doesn't waste time, right? And the whole idea behind that, court time is very precious. One of the reasons why we have a lot of persons on remand or a lot of persons spending a lot of time waiting for trial is because there simply isn't enough judicial time. Once we realize that there's not enough judicial time, it behoves us to ensure that every single second counts because it's precious. But then that's a discussion for another day. But I just thought I would make reference to that. I want to make a quick remark too about this whole issue of parents receiving money for to drop sexual offense matters involving their children. That's something I'm very passionate about. It's a particular matter I'm looking at. And if I can get the relevant persons to give the evidence, there will be a mother charged with that particular offense. Because that kind of behavior, that should be stamped out in any jurisdiction. When you start to take money to drop a matter involving your child, you become a pimp for your child, and you're setting a bad example. Maybe setting up your child to do the same thing when she becomes a mother. No. So if somebody has to take a stand against that kind of activity here in St. Kitts and Nevis for the first time, let that be me. And I'll take whatever comes with it. What is wrong is wrong. I just thought I'd throw that in.
Right, okay, and certainly that is something that we can discuss a lot more along the line. But we are going to take a final break, AG. When we come back, we'll discuss this citizenship and investment program. Stay with us. We'll be right back with more In Focus.
If you haven't done it as yet, please do it today. Subscribe to our YouTube page at SKNIS Media for regular updates, live coverage, and even more information on your government. While you're at it, like, share, and interact with our Facebook and Instagram pages at SKNIS Media and SKNIS Info.
Welcome back to In Focus. We're having a discussion with criminal justice reform with the Attorney General, the Honorable Garth Wilkin, and Director of Public Prosecutions, Mr. Adlai Smith. Now, AG, we spoke a lot about transforming St. Kitts and Nevis through the laws, of course, that deals with criminal justice reform. But looking at persons who would commit crimes and becoming citizens of St. Kitts and Nevis through our CBI program is something that the government also has been key to ensure that this doesn't happen, to keep the bad actors out, so to speak. So let's talk a bit about the CBI. And of course, there is a case that is trending here in St. Kitts and Nevis that has been filed against the government involving the CBI. What can you tell us about that?
Well, there's a local case that is a judicial review, which is a challenge of a decision. So it's not really suing the government, it's seeking to challenge the decision of a minister in the government. We have applied to have that struck out. So it is in process. I can't speak much about it, but it will take its natural course and we go from there. And then there's a US matter that involves individuals. The government is not a part of that matter in any way. But I can tell you, the most important factor in citizenship by investment is our due diligence process. I have sat in meetings with the other stakeholders in the region, with our international partners. And I can tell you, if it's one thing that is clear around the room when each group talks, is that everybody is serious about their due diligence. Because you don't want, you're trying to resolve the crime problems locally. You don't want to import any other criminal problems. So that is key for all of the programs in the region. There's now further strengthening because of the memorandum of agreement between the 5 CBI territories in the Caribbean. We're going to share further information. We already share information with the JRCC, which is a part of CARICOM Impacts, which is really our international partners working with us on crime-related matters. They check all of the databases before they approve persons. Files go to the FIU, which is the Financial Intelligence Unit, for checks. International due diligence companies do their checks. So there are lots of different processes to protect us. The legislative step that was recently taken was the Citizenship by Investment Unit Act, which sets up the unit as a statutory corporation. the unit conducts a lot of transactions. They process the applications. My personal view is that when you have an arm of government that is doing transactions as their main business, then it really should operate as a statutory corporation, because within the constraints of the Crown's budgetary and strict systems, it doesn't fit well, because if you're taking in money and you're paying out money, it's better as you have a accounting department and that kind of structure, a board of directors and all of that.
Makes it more efficient.
It makes it more efficient. And it was a recommendation from our international partners as well. There was a report that was published in November 2023 by the OECD that kind of made recommendations of how we could strengthen. It's all about evolution. It's a 40-year program, it evolves with time. And we felt that it was necessary to take that professionalized step, like some of the other jurisdictions have already, to remove it as a government department and move it into a statutory corporation. I think the DPP would be happy if his DPP's office was a statutory corporation, because he wouldn't have certain constraints.
If we had big space.
That's for a private conversation. DPP. But you know, it modernizes, it protects this structure and the system, and all we've done since taking office is try to strengthen the system. We started by changing the regulations very early, December 2022. We amended them again in February 2023, again in July 2023. We've been in constant dialogue with our international partners. They get all of our statistics. We sit down with them and we have honest, frank discussions with them about the program. The Prime Minister has led and been able to convince the other islands that we need to come together. I mean, I don't think people are realizing how big of a step that was to get everyone to harmonize. The only person that is yet to implement the harmonization is Antigua, because they have an issue with Parliament, because one of the parliamentarians, I think, is ill. So they haven't been able to actually go into Parliament to get it done, but they've promised to get it done, and they've already said what we're going to do when we are able to convene Parliament to get it done. That is a giant step. A giant step in all of the things that we agreed. We agreed with the US as to certain processes, for example, interviews of applicants. That was since, I think, February 2023. So there's been a constant process of reform over the last 22 months or so.
And the bill that you mentioned, the act, it was an act passed in Parliament on June 15th. It also introduced a continuing international due diligence unit.
Yes, that is an arm of the Ministry of National Security. It's something that we created here. We thought it was necessary not just to do due diligence in the application stage, but to do a continuing due diligence internationally. So what it's responsible for, it's ensuring that persons with St. Kitts and Nevis passports who live outside, live internationally, work internationally, are complying with international laws and the laws of their country. Also, it's there to investigate. So if Interpol says, listen, we are investigating a citizen of St. Kitts and Nevis, can you give us some information? And they could then partner with the international law enforcement agencies to resolve those kind of matters. Also retrieve passports. So sometimes passports are cancelled, so the office will be responsible for actually going and retrieving the cancelled passports, which is something that the international partners have discussed with us, to remove them. Even though they're deactivated, you can't use them. You still want to collect them, retrieve them, yes. And also it's to advise the minister, so develop policies and about how the continuing due diligence is done. So we are hoping our model will be adopted by the other territories. In the MOA, we've agreed to each do a continuing due diligence structure. This is our structure, the CIDD, Continuing International Due Diligence Unit, was our idea. We are going to put someone there. We've already engaged with our former Commissioner of Police to run that. He is trained with all of the international agencies, familiar with that space.
And that will be Ian Quealy.
Yes, and so he's ambassador for the OECS to Morocco at the moment. So somebody who's serious and who has connections already, because at the end of the day, it's a connection-based thing. You want somebody who the international partners can speak to. I can tell you frankly, We raised this for the first time in October last year, that this is what we are planning to do, to get this in place. And eyes opened up in the meetings, because it's a great idea. Because what you want to do is, there are citizens all over the world, you want to be able to have a liaison entity that is based out there that can make people feel comfortable.
You mentioned transforming the unit, and the Prime Minister, of course, made the case in Parliament when the bill was being debated, transforming the unit from a government department to a statutory corporation. How will that help to enhance the functions of the unit, and also how does that affect the structure of the unit in terms of the hierarchy?
Yes, well, the legislation requires there to be, I think it's 4 officers. So the actual statutory body is made up of the board of directors, called the board of governors, the 4 persons, which is the CEO, the chief financial officer, the chief due diligence and AML compliance officer, and the chief marketing officer. So those 4 jobs will be created, and then the staff. So what's going to happen from a practical perspective? I think it's important for people to know. Once the board of directors, board of governors is installed within days, they will then begin work to structure the office. So they will meet with the current unit, head of the unit, and figure out a plan for the staffing structure of the office to be most efficient. They will then interview, hire, and then when they're ready to, they will of course interview the persons that are currently there and so forth. And then when they're ready to actually roll out, they will then hire with the statutory corporation. It's been done before. SCASPA, Tourism Authority. There are various examples that government has done this, where a department has converted into a statutory corporation. And naturally, what we've done is we've created the structure so that they have to report their audits to Parliament, and they have to conduct reports. One of the things that our international partners ask for are either annual or biannual independent audits, not of the finances, but of the operations. So that will allow them to be able to solicit major firms to be able to do those things, and they're going to run off of their own. So the due diligence fees that they receive on applications will be their income, and they will then, if there needs to be budgetary support, they can ask for it, and there needs to be appropriation for the first set of capital to start them, to get them going. But I think it's important to say, the main money that comes into the unit, which is the contributions and the application, the post-approval application fees, that's the significant funds, those will be paid into the consolidated fund. I think that is very important. The unit will run off of its basic application fees and their IMA and service provider registration fees and so forth. The main money still comes to the government. And then there's a provision that allows the cabinet to decide. Say, for example, there's a shortfall in a particular year in the unit, they can assign a percentage up to 50% of the post-approval in principle application fees for the operations. But that has to be approved by the FS, and there's a structure there. There's a control structure for that. So I want that to be clear. It is a unit that is there to run efficiently. It's an important element of our economy. We're trying to diversify. We're doing everything we can to diversify, to rely less on that income. But this is part of it, professionalizing it, and then we focus on the other aspects of the economy. So it has been thought out. A lot of thought has been going into reforming CBI. And I've done a lot of work here, and I can tell you, since day one, done a lot of work, regulations, policies, all of those things to fix the CBI program.
Okay, unfortunately, gentlemen, we are out of time.
The time run by too fast.
I'm telling you, when we have the 2 of you on, we need to extend the show to 2 hours or something.
And I think that's because of you, not me.
Well, but there it is. But let me just say, I mean, I know we were speaking about it before the program. What I would like to see is, I know you said we could have the interactive, but if I could appeal to management, get the interactive aspect of it ready so that we can have a program where people can call in and express their views. And I'm talking about
another show, but you can do that on another ZIZ show.
We can't do it on this show.
Well, there's some issues with the lines that ZIZ is upgrading, so we'll have that hopefully shortly done.
Yeah.
So we will have that interactive, and then we'll probably have to have a 3-hour show. Because
Well,
we have to account
if
for
it's
the
that
public
time,
as well.
You have the
Just
time,
make the
DPP?
time.
You have the time?
No, but it's an important issue.
Yes,
Yes, and
Right?
it's something that, of course, at SKNIS we are concerned about, because, of course, we want to hear the public, and we understand that
Yes.
the public needs to interact with public officials, not just those who are elected, but those who they serve within the civil service. Gentlemen,
Right, we're
I'd
public
like to-
servants, not
Yes.
public masters.
Yep.
Yes, we'd like to thank you very much for joining us for this edition of InFocus.
Thanks for having us, Ian.
Yes. I'd like to thank you, viewers and listeners, for joining us for this edition. We trust that you will join us next week at the same place at the same time. I'm Ian Richards.
Join us every Wednesday for InFocus, a weekly talk show produced by the SKNIS Information Service, where we provide exclusives with key persons within the government and discuss pertinent, relevant, and interesting matters that affect us all. Tune in every Wednesday, live on ZIZ Radio and streamed live on Facebook at SKNIS Media and ZIZ Online. InFocus, your government, your business.